afternoon and very good evening to everyone present here and the viewers who are continuously watching us through Farid Nisha's channel. And very good evening, sir. This is the third program it seems we are doing together. Where in today's topic we are going to talk about our guest is going to talk about civil law in a common law countries. So, talking about Mr. Edrich Miranda, sir, a small introduction about our chief guest today. So, sir has a vast experience as a technician in oil and gas industries, onshore as well as offshore, in many countries, and more than that, he has been working as senior journalist, and he has a vast experience in the court halls, like appearing for bar council lectures series, and he has appeared in many countries, and he has a lot of backup with cyber securities and Chinese laws, comparison of American and Indian constitutions, comparisons of Chinese and common laws. He even used to write as an author. If you feel, if you want to go with the author's view, you can just go check it up in the link. I will get the link from the sir and the book, and I will just put it over, so you can just read those books as well. And coming to our today's topic is that civil law in a common law country. So, and we have our chief guest who is going to give an elaborated session on this for another 1 hour to 45 minutes. So, I think so. This introduction is very much enough. So,
Thank you
sir,
so
I will
much.
give you the platform to you, sir, and you please carry on. I'm very much eager to listen to your session. So, please take the platform, sir.
Yes, good evening, everybody, and thank you so much, Advocate Nisha ji, for your kindness and propagating the subject. I'll start with posing a question to the audience, just as a sort of, preparatory ground, so that we get a good foundation to the subject. What would you understand by civil law? Is there anybody in the audience who would like to try, take a try at least? Those who have completed their graduation in law. Anybody would want to try? What is your understanding of civil law? What do you mean by civil law? Is there anybody who would want to volunteer and take a try? Okay. Since since nobody's coming forward, I will proceed by saying, today I tried to go onto the net, and since I had a seminar in the evening, I said I'll just have a cursory look as to what the net says, other than what I have studied. So I tried to get something from the net, and it was laughable. Some platform in UK who leaves their platform open to anybody who wants to use it and project their ideas as a blog or whatever. They've defined civil law as civil proceedings that we have in Indian courts, like the CPC, any civil dispute of contracts or whatever of that nature. So there is a great misunderstanding of civil law and civil procedure that is followed in India. When we say civil law, we mean civil jurisdiction, because there are different types of laws all over the globe. To name a few, there is common law, then we have civil law, we have Chinese law, wherein there exists a similarity of Marxism, Leninism, and Maoism all these three together constitute Chinese law, and it is used in communist countries mainly, and the satellites of communist countries. Okay. Then comes the Islamic law. Then you have the traditional African law, and of course you have something known as canon law. Now this canon law joke, I'll keep it to the end so that otherwise people don't understand, because one canon law gives a wrong impression. Sometimes quite a lot of people, the fresh crop of advocates, they don't know what is canon law. They've never heard about canon law. Nobody practices it in many countries. Even in India, is lesser known. Now, broadly, the difference between common law and civil law is common law in common law countries. For example, our country, India, we are a common law country because we belong to the Commonwealth, and we derive our legal system from the British. Wherever the British have ruled, they have left a legacy of common law. And various other countries follow common law. Wherever there was a British Empire extended, common law was there. But there was also something known as civil law. This civil law originated and was practiced and is being practiced in Spain, Portugal, France, Austria, Germany, and all those countries towards the uh, southern border of Europe. So we will confine ourselves to civil law, but civil law has been imported from there, from these countries. These countries practice, except the Soviet Union, I mean the erstwhile Soviet Union, and and Great Britain. They had a different law. Otherwise, the entire whole of Europe had this law, civil law. In civil law countries where the judges presiding over a dispute in common law are essentially guided by the statute. When a judge is presiding over any dispute that comes before him or her, they are guided by a statute. The statute has been laid down by the legislature. No doubt, the courts interpret the law and the legislature legislates the law. Nevertheless, the courts are bound to go by the legislature, save and except if they have a special reason for deviating from the legislation. So by and large, we go by the judges are guided by the statute. That is one part of it. The second aspect of it is they are also bound by precedents. And by precedents, we mean case law. So judges of subordinate courts, magistrate court, session court, high court, they are bound by the orders of by the case law of the Supreme Court. And I don't need to tell you that because of being students and advocates, everybody knows under Article 141 of the Constitution of India 1950, all subordinate courts are bound by the bound by the judgments of the Supreme Court. So the second condition is that in common law countries, we are bound by the orders of the Supreme Court. First is that we have to go according to legislative laws. And the third is judges have to peruse documents and hear submissions of adversaries. When we say adversaries, we mean applicant and opposite party or petition and respondent or whatever. And they are both each requires an adversary. Your other part, if I am a complainant to the accused, then the accused is an adversary to me. So we are governed by the rules of adversaries. Judges are supposed to peruse the documents which have been placed on record, hear the acts of the parties, and arrive at a judgment based on facts and law. And that is known as the got that? This is the adversarial system. Coming to civil law, judges presiding over disputes in civil law need not be bound by a statute. You see the flexibility and the freedom that they have. This kind of freedom only the Supreme Court has, and to an extent the High Court has. The High Court has the freedom to traverse beyond the law in certain cases. For example, if a matter comes before the Honorable High Court under 482 or 483 of the CRT or 26 to 27 Constitution, court can do anything not mentioned in the statute. So the court has flexibility. Same in matters in matters 483. It will be 150 and 153, I think. I think it's 150 and my memory is 151, 153. And in an constitutional matter in the under the writ jurisdiction, 226, 227. So courts have flexibility to an extent only if it is common law country. But when you're applying civil law, even the magistrate has the flexibility. So you don't have to go in session court and to the High Court and in appeal and in revision and things like that to get the benefit of the flexibility. Flexibility can be obtained right at the inception at the trial court itself. Okay. Okay. Now we'll come to Now here again you have a nice feature in civil law. Judges are not bound by precedent, which means they are not bound by case law. If a matter has traversed and gone up to the Supreme Court, and the Supreme Court, I mean in a civil law country, it has gone up to the Supreme Court and the Honorable Supreme Court has passed an order. That order need not be final and that order need not be religiously followed. A judge of a trial court can overrule the order of the Supreme Court. He has that much of power and authority vested in him. Whether he utilizes it or not, he has to do what he wants. Then another unique check about this is after the judges have perused all documents and heard all parties, they have the right and they have the liberty to probe in water without any part requesting such a probe. If no party in this proceeding might raise the objection with regard to some which may not have come on record or whatever, but the judge of his own suo motu can ask for a reprobe, can ask for a further probe, which would not be acceptable in a common law country. The reason being, I'll tell you the reason also why it's not feasible in a common law country. The reason being, if a particular matter was sent for investigation to police or any investigative agency, and they furnish their report, thereafter, if the same thing or it does not satisfy a judge, and if he sends it further for a report again, a second report comes, maybe erroneously or whatever. And then the question paramount will be as to which report should be relied upon why should it be relied upon? Two reports will come. Each party will try to derive favor or derive mileage for whichever report is favorable to themselves. So then again there will be a dispute as to which report is correct and which is incorrect. Therefore, you cannot have a further probe. Once a probe has been conducted and a report has been furnished, that's it. If it was erroneously furnished, that is your misfortune. If somebody could not investigate properly. This system is known as the inquisitorial system. Inquisitorial system. Not inquiring into and investigating into, probing further into the system, where judges can ask questions to parties, judges can call for material from either parties or strangers to the proceedings, or authorities with whom the relevant facts lie. So this system is known as the inquisitorial system. The earlier system was an adversarial system. Now coming to civil law in India is used in the union territories of Silvassa, Nagar Haveli, Daman, Diu, Pondicherry, and it is also used in the regional state of Goa. Did you get that? Hello?
Yes, sir. Yes, sir.
The civil law in India is used in the union territories of Silvassa, Nagar Haveli, Daman, Diu, and Pondicherry, or in the regional Goa. Currently, as per the Treaty of Secession, no Indian statutes are applicable to those of French nationality still residing in Pondicherry. Those who sought Indian nationality can still be governed under the French Civil Code. Something similar exists in regional states of Goa and union territories of Silvassa, Nagar Haveli, Daman, and Diu. As far as Pondicherry is concerned, it was a French colony, and the French Civil Code is applicable over there. But as far as Nagar Haveli, Silvassa, Daman, Diu, and Goa are concerned, these were Portuguese colonies, and therefore the Portuguese Civil Code is applicable over there. There isn't a consistency of privilege laws in India, and a disparity exists, which is little known to the general public. I would not hesitate to say, which includes advocates, judges, professors of law at law college, and others connected with the field of law. Now let us for a moment slightly deviate from the subject of civil law. Just for a moment, in order to get a good grasp of what exactly this law is all about. Because there isn't any consistency. You have a different law in Kashmir, you have a different law in Arunachal Pradesh, you have a different law in Nagaland, Mizoram, and you have something in Goa, you have something in Pondicherry, you have something elsewhere. So how states and union territories are privileged? Until recently, Kashmir was privileged under Article 370. But now that privilege has been done away with. Of course, not all the privileges, but quite a lot of privileges have gone away. But people only talk about, and everybody knows about this, that this Article 370, it has gone drilled into the head of various people. Every student, every person traveling in the train, commuters, bus, and train, everybody is discussing about Article 370. This, fair enough, Article 370 of our Constitution is known to everyone. And because there has been much hype, and because of the ignorant media and vested interests of politicians, I will not hesitate to say ignorant media, even though I am from the media myself. The truth is the truth. And politicians have their own agenda. until recently there has been a lot of heartburn about some special privileges conferred onto Kashmiris. Similar or even worse laws exist in certain other Indian states, but evokes no hue and cry. For example, Nagaland, Arunachal Pradesh. In Nagaland, you won't believe me if I say I'll request you to look into the constitution for yourself and you can see it for yourself rather than believe me. Everybody talks about Article 370. Nobody talks about Article 371A. Can't they go a little further? Just a little further. One article. 370 is the hype. 371A tells you about Nagaland or Mizoram. Nagaland has a special law. The law in Nagaland, the law laid down by Parliament of India is not applicable to Nagaland. Nagaland has a privilege. The law will become applicable to them when and only when their assembly ratifies it. It's ridiculous. Who is big? The state or the center? Nevertheless, I just brought this fact to show how the law operates. Same thing we have in Arunachal Pradesh. If I come to Tamil Nadu, I can get domicile if I stay in Tamil Nadu for a couple of years or whatever, or some years period. If you come to Maharashtra, you can get domicile in Maharashtra. But if you go to Arunachal Pradesh, you cannot get domicile there. Domicile is not given to anyone. Therefore, you cannot get a job in the government. You cannot get admission for your children in school and colleges. And you cannot get a lot of other things because you cannot get domicile. So isn't that a disadvantage comparatively with the rest of India? We are at a receiving end, other Indians. But nobody utters a word about it. Same thing is here. Now, let us come back to Portuguese law. The Portuguese Civil Code and the French Civil Code, both of which are even applicable today to certain union territories and a regional state, actually govern the civil aspect of disputes. If there is any criminal dispute, any fight or anything, or theft, robbery, stabbing, or any criminal act, the law is consistent all over India. There is a similarity in the law, there is a consistency in the law, but as far as civil matters are concerned, Contracts Act, Marriage Act, and Registration Act, and certain other things, testimony proceedings, these are civil proceedings. These proceedings in Pondicherry, in Goa, in Union territories of Dadra, Nagar Haveli, etc., and in certain other states, these proceedings are governed according to the respective codes. French Civil Code, the Portuguese Civil Code, or the local acts of the Nagas, or whatever. Let us take what are the special features? Let us examine the special features of this civil law. Let us take an example of a gift. Let's take an example of a gift. Suppose A gifts a property. The property is known as B, and is gifted to C. The name of the property is B. A is a person who gives B to C. C is another person. So a deed is drawn out, and the same is registered at the office of a sub-register, office of a register, or the office of a sub-register of assurances of a respective district or whatever. So now, once the deed is registered and signed and numbered, stamped and sealed, thereafter there is what you call title of the property flows or is transmitted. The title of the property which earlier earlier was with A is transmitted or it flows to C. A is the donor, what we call donor in normal in the legal terms. A is the donor, and C is the donee, recipient. Once the title of the property has transferred from A to C, thereafter A cannot take the property back by cancelling the agreement or by raising any grievance or by reversing the transaction or whatever. Because the simple reason being, after the property is transferred to C, from A to C, C has absolute title to the property, and A is divested of his rights and the right, interest, and title to the property. So A ab initio has no locus standi to sell that property, to reverse it, or to do anything to it, nor even to cancel that agreement. Once I make an agreement and I give a property to XYZ, thereafter I cannot take it back in common law. But in civil law, you can take it back. It is permissible. This is how the civil law operates. Civil law actually is more of a social legislation. All these things were incorporated in a law taking into consideration the situation during those times and how the people of the local people were being adversely affected. Portuguese came from abroad. They established themselves in Goa, Damandu, etc. They created atrocities on people. The Portuguese armed forces forcefully had sexual relationship with ladies, and they did a lot of wrong things. Children were born. As to how the children are going to be fed, clothed, accommodated, what surname they would have, whether they would have right to properties, legacy, all these factors rose up for consideration. And accordingly, the Portuguese administrators in Portugal crafted out the law in such a manner that people who were adversely affected, children born out of wedlock, would get a proper surname, would get a proper share of the legacy, would get proper protection and maintenance, etc. So it was more of a piece of social legislation, which continued from that time and it continues up to date. Let us take another example. In fact, it is a unique example. A property standing either in the joint or individual name. Mind you, a property standing either in the joint or individual names of spouses. Spouses mean husband and wife. If one expires, 50% of the aggregate goes to the surviving spouse as of right. 50% of whatever property exists goes to the spouse, living spouse who survives as of right. It is a statutory right and not a contractual right. In such a scenario, if I expire, I'm taking the example of myself. If I expire, 50% of my property will automatically go to my wife. Now, what are the dangers and what are the benefits and disadvantages of this? The advantage is that my wife will not be left on the street. She doesn't become a pauper overnight if I go away. There is adequate protection taken by the government itself, by the legislature itself, to safeguard her interest. Same with me. If she dies, my interests also are safeguarded in the manner hers are safeguarded. So the law is equal for everybody, both the sexes. There is no differentiation. Now, in such a scenario, assuming I have borrowed a sum of rupees 20 lakh from some bank or financial institution or whatever, and that 20 lakh is all I have. My total net worth is 20 lakh. All my assets and other properties, immovable and everything, works out to 20 lakh. In the event I die, the person who has to recover money from me, whoever it may be, an institution, bank, or a private party, or whoever it may be, if they are to recover money from me, they can recover only 10 lakh. Because 10 lakh will go automatically to the surviving spouse. So banks and other institutions will be at a distinct disadvantage, and therefore banking personnel who are you can say in-house advocates or whatever, in-house legal advisors, they should be very particularly careful of this aspect, because they will not be able to recover the full 20 lakh under any circumstances by operation of law and not by a contract. Your contract be blown to the wind. Whatever you may have contracted, anything, it has no significance. It cannot override the statutory provisions. So this is another feature. Then again we have another feature. So also with dispersal of legacy, if one of the spouses expire, as to how his her legacy is to be distributed has been specifically defined. In the event of a spouse, any one spouse or both expiring at the same time or otherwise, how the legacy is to be distributed, it is something akin to Muslim law. You see, among the Muslims, you have husband gets so much, in-laws get so much, distant relatives get this much. So also with this. So also with Portuguese law, the civil law. It is distributed vertically as well as linearly. Vertically meaning share will have to be given to the father, to the surviving father or grandfather, if the child has prematurely died. Suppose I expire before my father expires or before my grandfather expires. Whatever is my property is to be distributed to my father and to my grandfather. And the proportion has been laid down there as to how much. Now, so also, how much goes to my children and grandchildren. So that is the vertical division. And the linear division is how much goes to my brother, sister, brothers or sisters, to my cousins or other surviving people up to the third degree. So see how meticulously they have evolved the law. They have built up the law so meticulously that everybody gets their appropriate share. Nobody is deprived of anything. Up to the third place, it is permissible to distribute the assets. So, also about wills. Now coming to wills. The entire property assets cannot be bequeathed to any one person. And even if it is bequeathed, can become inoperative as of law. Even if it is bequeathed. Sometimes, now let us take an example. My father bequeathed all his property to me in a will. And the will for all other purposes is valid. Signed, sealed, everything, kept with a notary and entry made, etc. But the reason why I'm saying notary is because wills are to be kept with notaries and entries are to be made in the for that particular law. Goa wills and it's a law in Goa for wills and other testamentary proceedings of 2012, which is incorporated from the civil law or Portuguese civil law. When I say civil law, I mean Portuguese civil law. So even if the property has been completely bequeathed to me, and supposing I was instrumental in killing my father, or I was instrumental in ill-treating my father during his lifetime, or I have tried to forge a will or or done something against his relatives, some offense which is a major offense, I automatically become disqualified to get that legacy because that is the law. The moment somebody points out or it comes to the knowledge of an authority that I have indulged in some mischievous thing to get the property or to get the or to forge the will or taking the signature of my deceased father through deceit or deception, or while he was not in his senses, or there was nobody else, or in confidentiality, I've taken it without informing the other siblings, or I have attempted to ill-treat him, or whatever. If I have not given him proper food, not given him proper accommodation, clothing, medical aid, if these points also are pointed out, I automatically become disqualified from getting the property, even though the legacy has been in my name and everything else is in order. So these are the special features that have been incorporated, taking into consideration the safety regards for parents, for um, for siblings, for spouses, etc., etc. But there are certain funny things that happen. Wills are most misunderstood by many advocates and even by some judges. I would dare to say it, even by some judges. But by and large, a lot of advocates in Bombay, which is a mecca of advocacy, of litigation, lot of advocates are ignorant of this fact that this law of legacy, the testamentary proceedings of go-ons, are not to be governed according to the law of India, according to the Indian Succession Act. They are to be governed according to the law of Special Notaries Act of Goa. And due to the deficiency of knowledge, or sometimes due to arrogance, or sometimes due to ignorance, matters are filed, matters are heard, matters are finally disposed of. You won't believe. The matter is finally disposed of by a competent court, when actually speaking, the court is not competent. And if you point out this, even in writing, there are some judges who are reluctant to stay the proceedings or discharge the proceedings on applying the rule that it's non-applicability or whatever, or the court doesn't have jurisdiction. Even if you give the case law, even if you give them the statute, they say, I shall proceed with the matter. If you are agreed, go in revision. And this is the case with many people, many advocates also. They say, no, my client is entitled to this. My client is entitled to that. He has a will. I say the will, if, there are rules governing the wills of go-ons. Go-ons who have got Portuguese citizenship and go-ons who don't have Portuguese citizenship also. The wills are to be sealed, signed by witnesses, kept with a particular notary, an entry should be made, and that seal should not be opened until the person has deceased, the deponent of the will has deceased. So after his deceased, then and then only all concerned parties have to be intimated, and the envelope should be opened in the presence of all parties. Been by advertisement, public notice, and even an advocate's notice. You have to use all means to get in touch with all concerned parties to the legacy. And when they are present, and their presence on the seal can be opened. If the seal is opened before, it negates the will. That will is no will at all in the eyes of law. Now, sudden funny situation arose. A party living in the UK of Goan descendants, having property in Bombay, one flat at Malad, Bombay, and other land in Goa, and some other properties in Goa. So now they have property at Goa, they have property at Bombay, which is where in the Indian Succession Act comes. In Goa, the Goan Succession Act comes, and in the UK, they have a separate act. Now, which act becomes applicable? The Goan Act becomes applicable. The Goan Act, the Civil Code becomes applicable. It overrides all the others. The property that is in Bombay also is to be incorporated, which is incorporated in the will essentially go within the boundaries of state harmonious. If it is smudged, if it has been or if it has been faded, if the will has faded, or it become wet, or it is eroded, that will becomes no will at all, and there will have to be a contested matter. So these are the special features of this. Now let us go to what do you call it? The Goan will is there is the wills used by in Goa are registered under Special Notaries Act. The Goa Succession Special Notaries and Inventories Proceeding Act 2012. Which was passed by the Legislative Assembly of Goa on 5th 8, 2016 and assented to by the Governor on 19/9, 2016. Now let us for a moment go to matrimonial matters. What are the special features about this civil code as far as matrimonial matters are concerned? Maintenance and alimony. A married couple jointly hold ownership to all the assets owned before after the marriage. You see the comparison between civil law and common law. In India, what do we have? In India, we have if the woman brings in Sridan or whatever you call it, sometimes Sridan, some people say dowry, people say something. There is a kind of air condition, whatever brings even much fixed deposit, whatever. Her property is her property, which comes from her parental, is separately as her property. His property is his as well as hers. Correct? Am I correct? If I'm not correct, correct me. That is the property of the husband as well as the wife. Wife's property is exclusively of the wife. There is nothing. But here is not the case in civil code. Become they have inherited to marriage, the property that they have acquired into marriage. All properties are clubbed together and become one consolidated property. So when it's to be divided, then also it is to be divided manner. So nobody is at a disadvantage. Couples take ownership of all owned before the marriage or acquired after the marriage by each spouse. As one can see how justiciable the law has been drafted, where no spouse has exclusive right to any property. It is the agglomerate property that has to be spoken about. The woman can't say this property came from her parental side, nor can the man say this property came from my parental side. Property which was in book marriage and that which was after marriage gets amalgamated. Personally would not hesitate to say this is a masterpiece of social education. sort of violations, naturally they're into contact with community. Yeah, this that is all the globe. So as a safety measure, some of this and large type of people. I don't mean to emphasize but I in the team with background undering a country which enjoy their lives in with skill or financially or but as of Christianity subdued their aggressors. Good Christians started as you all know when because the church was all head of the scene, and the church was and the king was head of the church. They invariably interfered in working of this for the better or for the worse, but they did it. So I will. I think I should take questions because there are lots of things that can be spoken about Contracts Act. The Contract Act also is different. We have various types of this thing. The Testamentary Act is different. The Marriage and Maintenance Act is different. Marriage is something like a contract. It's not a sacrament. Christian marriage otherwise would have been a sacramental thing. But Christian marriage in Goa, church marriage is not recognized by state. You can have your church marriage. You will be given a certificate, but that certificate is to be used in your community and for your age, and the state doesn't recognize it. The state will recognize it only after you have registered marriage in accordance with the laws of the state. And some people who want to circumvent the law just go a few kilometers outside the boundary of the state, get married, and come back. So for them, that law is applicable because the marriage was solemnized beyond the boundaries of Goa or beyond the boundaries of Daman, Diu, etc. And therefore, that law doesn't become applicable to them. Just like some people want to drink liquor from Gujarat, where liquor is not permitted, they come to Goa, come to Daman, Diu, Silvassa, drink and go back. Same way, if somebody wants to get married and circumvent the law, they they go a few kilometers outside the state boundaries, get married in some temple or church or whatever, and come back. Then Indian law becomes applicable to them. These are the tricks of the trade. Can we have questions, ma'am? Hello? 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 Can we have questions? Can we have questions? Can we have questions, ma'am? Hello?
Yes, sir, you're audible, sir.
Can we have questions?
Yeah, okay, fine. Let me read few questions which have came in WhatsApp, sir. So the question is
Yeah.
like we discussed about Article 371A, which is special provision with respect to the state of Nagaland, right? So they have asked a
Yes,
similar
ma'am.
like Articles 371, which talks about Maharashtra and Gujarat, and following that they are very commonly they talk about special provisions. What do you think about it? Because only 370 has been
Uh,
focused, which is the temporary provisions with respect to the state of Jammu and Kashmir has been focused, and they have made it with the solutions. And what about the special provisions?
wouldn't want to criticize anybody, and I don't want to get involved in politics. But I would say, to my personal private view, that there should be some consistency in the law. You don't have to. You shouldn't be partial and give some privileges to some state. If you want to, everybody says that we should introduce a common civil code. No, I don't agree with this. You should introduce a common. What do you mean by you should? We should introduce the common civil code in India. It is already existing in Goa. The common civil code is already existing in Goa. So your statement should be, the person's statement should be, any person's statement should be, we should extend the common civil code from Goa to the rest of India. That would be appropriate. Rather than saying we should introduce common civil code in India. This is already existing in India. Isn't Goa part of India?
It is a union territory, no, sir.
Yes.
Audience, would you like to give a answer to sir's question? Yes, I can proceed, sir. They are listening, it seems.
Tell me. What else is required? So, so there's, so we have special laws everywhere. But these special laws are going to create a chaos. Uh, I wouldn't want to criticize that because somebody might think I'm against a particular government. I've got nothing to do with politics.
Yes.
I'm purely on academics.
Yes, sir. Thank you. Thank you
Take the
for
case
that
of
answer, sir.
Arunachal Pradesh. Take the case of Arunachal Pradesh. If we go there, we will not get domicile, and therefore we cannot get jobs. Nor can we get admission to colleges. And how about that? But if they come to the rest of India, they get everything. And there is a funny part of it. Why talk about Arunachal Pradesh? Talk about Nepal, which is a separate country. They've got a separate thing, they've got this government. But Nepal have got Indian passport. There are Nepalis working in the Indian government jobs, holding Indian government jobs. Why don't people try to look at that aspect of it? It could be dangerous for the country as well. Their loyalty lies with the king. When the king dies, they start crying. When our prime minister dies, they don't cry. Isn't it dangerous to the state? So we should be careful.
Yes. Thank you so much, sir. So the next question is that we talked about Article 141 of Constitution of India. Could you please give some insights on it, sir?
Yeah. Article 141 is an article in the Constitution of India that states any order passed, any judgment passed by the Honorable Supreme Court of India is binding on all subordinate courts. And that stays binding until it is reversed by the, or it is negated by the Supreme Court itself. Because only the Supreme Court can change its own order. Other courts do not have the authority to change their own order.
Yes, sir.
I mean, that in a nutshell, I've given you.
Yes, sir. Yes, sir. Yes, sir. Thank you so much, sir. The questions are, I think so, it's more than enough. and I would like to give a formal vote of thanks to you. So thank you so much for spending your valuable time with us. I think so you're always busy a person, but giving a time to make sure all the audience, like in YouTube channel as well, they should benefit. You have come up with a very good topic, which is civil law used in common law countries. Yes, as you said, we have lot of combinations of laws we use from UK, USA, and a lot more countries we have adopted, and we have constituted our Constitution of India. And we do have, as you said, the traces of Portuguese, and all of the people who ruled us have left their paths and footprints are there, which we are still following it. And you have occupied, and you have given a vast information regarding marriage and what are the illegal ways people misuse of the laws and articles, and even the civil laws which has been covered up with the Great Britain magistrates and Supreme Courts. Most importantly, you just covered the articles of Constitution of India, which is very important, because as you said, media persons, not only media persons, nobody is coming up to talk about that and touch that point as well. And acquisition and records and facts of law and everything, it was so amazing, sir, because this view has not been focused anywhere else, and nobody talks about it as well. In based on the civil law, you have given a lot of insights. I hope so. I will go through it again for the reference, and thank you so much, sir, because time is very valuable, and you have been proving me again and again to the audience as well as to the all the participants that this education and learning and unlearning is very important to each of us till our last breath. So, thank you so much for sharing your valuable experience and opinions to us to reach out all the people. So, this will helpful in future generations and future people who are going to see in social media who are active when they come to understand how important the law is, how important article is, how important these topics are, and these people will come at when they will come us and proceed with us to know more about it. And thank you so much. Within a short period, more than 30 to 45 minutes, you just covered a lot of areas. And thank you so much, because even in classrooms we are not able to cover it up. A syllabus, you as sir knows, whenever we go for lecture classes, it is not enough. Even though it is a 6 month on 1 year period, of course it is not enough, but you have given a gist of ideas, touching upon all the areas. You didn't leave any area, like you talked about Islamic law, you talked about African law, Canon's law, Marxian law, and lot more. So thank you so much for sharing your knowledge, sir. I feel very privileged. Each and every time I feel very happy whenever you give some topics to talk about. So thank you so much. It will reach a large audience, sir. I'm sure.
You should be thanking me
Yes.
also.
Thank you so much, sir. Thank you so much. And participant, you can message me personally to get your e-certificates. You can put your contact number in my number, so I will just tap you over there, and people can send me a message that you have attended. So I will put forward my number. So thank you so much, sir. Thank you so much. I hope it is a very good day for me, and we will continue next month as well. Thank you, sir. Thank you. Let us end the meeting.
God willing, we should continue.
Yes, sir. Oh, any few words, sir? Few words. The end of the session. Would you like to, sir?
Yeah, sir. I think I should end it with a sort of jocular thing, something to smile about. I remember two occasions where I had used canon law. Once I used it at Delhi before the Press Council of India, and once I used it before a magistrate. And the magistrate was so infuriated with me, he got angry with me. So, what nonsense are you talking? Do you know law? They're asking me. I said, I beg to differ with you, my lord, with due respect. There is something known as canon law. Kya canon law? Canon law laga rakha hai. He couldn't understand what is canon law. And he was angry with me. But somehow I managed to convince him and told him that the canon law is a law that is practiced at the Vatican. Vatican is a state within a state. Vatican is a sovereign state within the state of Italy. It's like having a Maharashtra state within, like we have in the US. We have in the US we have Supreme Court of, say, Manhattan. Manhattan is just a regional state. You cannot have a Supreme Court of Manhattan, but they do have it there. Here we cannot have a Supreme Court of Tamil Nadu or a Supreme Court of Maharashtra. You have a Supreme Court of India as a whole.
Yes.
So therefore, he could not understand, and I told him that this canon law is something to do with Christianity.
Yes, sir.
And finally, other advocates convinced him and told him, then he calmed down. So by not having adequate knowledge of law, sometimes even at the Press Council of India, I was representing somebody and I said, according to canon law, this priest could not have done this thing. Because being a priest, he cannot indulge in politics. He is barred. Yes, as per canon law. So they said, what canon law are you talking about? What is canon law? I said, now I can't go about explaining to you what is canon law. I presume you didn't know what is canon law. So this is what happens. Sometimes you come into a very funny situation, but you pass it off as a joke. Just smile and peacefully pass it off.
Yes, sir. Yes, sir. Really, it is true. It is a true fact. We need to learn because whatever we are learning is just a little lump sum, but we have huge world and huge universe to learn and unlearn the space as well. So thank you so much for highlighting that, and thank you, audience. We will meet in the next meeting.
He was thinking that canon means that cannon were to be used in the army for the armed forces. That canon. Yeah. He was thinking of that canon.
Yes, sir. Yes, sir. Yes, sir. Even a similar topic talking about Holy See was talked for more than 1 hour by a person who is in abroad. I was likely to attend that conference webinar. It was very useful, but it was very new to me. As you said, similarly, if we doesn't understand the topic, we should search and re-research, and we need to read and read and read. That is the only mantra to learn a lot of unlearned things. And thank you for highlighting, sir. Thank you so much. We'll end the meeting. Thank you, sir. Thank you, audience. Thank you.
Call it a day. I'm through.